I was up reading court cases until midnight last night so that you could watch the new South Park. I'll catch you up if you tell me whether you think Matt and Trey still got it. Happy Thursday, everybody. I am Brian, and this is the morning report for the federal courts for August 21st, 2025. Please do me a favor, drop a comment or a like, and if at all possible, watch the whole video. It helps get this out to people. And thank you, Lauren and Pat, for your Venmo support. It's the only way I can keep doing this. Got a couple of pretty cool stories today. Grab your coffee and get comfy. I'll catch you up. All right. The state of Mississippi may have an important change coming to its Supreme Court. See, the historically African-American Mississippi Delta region runs generally along the west side of the state of Mississippi from the north end to about the center of the state. But the state has been divided into 3 regions, each responsible for choosing Supreme Court justices. And those lines run, well, we'll call them east to west. And one of those lines cuts the Mississippi Delta region right in half. Or, so said a federal district judge yesterday in White v. State Board of Elections. And this is how the judge said Mississippi has avoided electing black justices for essentially its entire history. 4 have been appointed and even re-elected, but none elected outright. And the judge said it's time for that to end. So, Mississippi must redraw its Supreme Court election map in a way that isn't so clearly designed to cut the Delta region in half and disenfranchise black voters. The state said it will review the decision and decide how to proceed. Okay, next we're heading back to Global Health Council v. Trump. This one is a bit of a roller coaster. We've talked about this before. It's actually 2 cases in one. I'm just calling it Global Health. But the past few days have been all over the place on this one, so buckle up for some very boringly harrowing tales here. This is one of those cases where a bunch of grants were supposed to be paid, Congress wrote the laws and appropriated the funds, and the president is refusing to pay. Back in March, the court instituted a preliminary injunction that said, you have to keep paying these. And then about a week ago, the D.C. Court of Appeals decided that the plaintiff in this case lacked standing, and the case was basically dismissed. Sort of. And this was a case where there was a lot of really dramatic news coverage, and I got really annoyed because it wasn't very accurate, if you guys remember. Well, the plaintiffs asked the D.C. court to rehear the case en banc, which means basically a bigger panel of judges. The first hearing was only 3 judges, and the court agreed. So maybe the payments are back? And the plaintiffs asked for a stay so that the payments would continue in the meantime, and the Court of Appeals said no. They denied the stay. Womp womp. But the court clarified yesterday morning that the stay is denied because, the first decision never went into effect. Ooh. So that original preliminary injunction was never stopped to begin with, so the payments have to continue. And that is where we are for now until the en banc Court of Appeals hearing, which should be sometime in September, I think I saw that. Now, NAACP v. United States. This is a case about the actions by the administration aimed at closing the Department of Education, either by just directly closing the department or functionally by cutting all of its staff and contracts and halting all the grants. And yesterday, a judge said that the defendant's motion to dismiss was denied, but mostly because she didn't feel like dealing with it yet and kind of told them to try it again later. But the plaintiff's motion for preliminary injunction was also denied in the same memo, so nobody's happy. Now, take a walk with me for a second because the reasoning on why she denied the preliminary injunction is interesting, and I think you should hear it. It's not the only reason she cited. I mean, this thing was like 36 pages, but it's the part I think you should hear. So a preliminary injunction requires the judge, among lots of other things, to determine that the plaintiff has a good chance of winning. Injunctions aren't supposed to be a way to get the court to give you a win for a little while when you're obviously going to lose. But the problem here is the judge looked around at these 400 some cases that you and I are talking about every single day with huge implications, like massive shifts possible in how we decide law. And she said, guys, there is no foundation here. There's no concrete for me to build an argument on where I can say with certainty that the plaintiffs are likely to win. The laws are changing way too fast. Now, I am not sure that I agree with her on her conclusion, but I don't think she's totally wrong. And this is sort of a problem because the courts are supposed to be our turtle, our snail, the slow part of government that changes like January molasses. Anybody get that reference? Bugs Bunny? She basically said, we're on shifting sands. I can't tell you with a straight face that I know today what the law is going to be in 6 months or a year when we decide this case. So it's a hot take. I'll give her that. And for now, Neither side is happy, so there. And the NAACP is a huge organization, so they may appeal this. I think I probably would. And I will let you know if they do. All right, last case for the day. This is Spectrum WTV Wendler. And this is one about a Texas student group that had a fundraiser with a drag show. And the university blocked the event, saying that it was not protected by the First Amendment because it was lewd conduct. And the district court sided with the university on two bases. First, the place where the fundraiser was going to be held on campus was something called a limited public forum. Now, I wrote a whole research project on limited public forums in law school. I'm not going to get started. But basically, it's something between a totally private place and a totally public place. And the First Amendment's kind of funny in the middle. And the second basis was that it was not clearly established that all drag shows are inherently expressive and therefore implicate the First Amendment. Now, I don't know how many of you have ever seen a drag show, but if there's one word I would not deny them, it is expressive. But let's head to the opinion. Now, I put a copy of the whole thing in my shared documents if you want to read it. It's in the subject matter library under freedom of speech. It's a great read if you want to take a long walk through the First Amendment, like through a good First Amendment evaluation. But bring a water bottle. It's a very long walk. Let me just give you a couple of high points from the opinion for now. And again, I'm summarizing the opinion. Most of this is just basically quotations. All right, for something to be speech, it needs to communicate some sort of message. And here, in this show, the performers were dressing as members of the opposite sex, dressing in drag, as a very clear message of support for the LGBTQ+ community. Now, it was a fundraiser in support of that cause, so the message was pretty clear. It was right there on the flyers. And the court says, dressing as a member of the opposite sex doesn't always mean the same thing. It doesn't have to be a clear message in support of the community, but here it clearly was. So there was a message, and therefore this was a form of expression or speech, and that implicated First Amendment protection. Then the court goes in to evaluate whether this was a public forum or a limited public forum. I'm not going to go into that. You can go read that on your own. And then the case sort of devolves into a discussion about exactly who is liable for what. There's a whole standing discussion, whether this person or that person at the university is responsible or whatever. The point is, the circuit court here has held that a drag show is expression and protected by the First Amendment. Now, this is not the first time this has happened. Several laws about drag performances have been overturned recently. Frankly, this one took a little bit longer than it probably should have. It took about 2 years. But for a conservative circuit court like the Fifth to double down on this point, as a lot of law is kind of pushing the other direction, is important to note. And Kavanaugh's mention of the First Amendment last week as an important keystone for him is also worth noting as we enter the more substantive phases of some of these 400 some cases that we're talking about every day. Because the First Amendment may show up in places you really might not expect. So keep your eye out. All right. That is your Thursday morning report on the past day in federal courts. Again, you can leave a comment or a like, get this out there. I would really appreciate it. And if you know someone who'd like this, share it with them. Otherwise, keep watching, everybody, and I will keep going. Thanks a lot, and have a great Thursday.